Hey everyone, this is Logan Hertz with Hazeltine LLC. Today we're going to be discussing a very important but oftentimes overlooked topic, and that is estate planning, which is one of the key components of any financial plan that needs to be in place. And we have with us today Mr. Mike Maloney. Mike Maloney has a third generation estate planning company. He's been in the business for 35 years, and he's going to educate us today on the basics of estate planning, what it is, why you should do it. Mike, good to have you on the program with us today. How you doing?
I'm doing very well. Thanks for having me.
Let's start with your company. Why don't you tell us a little bit about your company and what you do?
Premier Estate Planning is a legal document firm. We're not a law firm. Even though we have an attorney on staff, he doesn't represent any particular client. He's involved in the preparation of our estate plans. I would say one of the better analogies to feel who Premier is we're a legal Zoom on steroids. The steroids part is we're education based. So anybody that is looking to have their estate planning done with us, we spend an ample amount of time providing our prospective clients with education on what legal documents solve what problems, so that when we're finished with our education process, the client understands that if they choose these particular documents, here are the results that those documents are going to achieve. And if they choose this type of planning document, the results are going to be achieved this way. And that way, the client is well informed and they know whether or not having a revocable trust or just a last will and testament is the right planning document for them. And they're able to make that choice for themselves based on the education. Now, the difference between a legal document firm and going to a lawyer is that a lawyer can give you advice and tell you what to do. So if you think you were the type of person that would need to be basically guided or advised what to do versus receive education and then based on that education, be able to make your own choice, if you don't think you could do that, then you want to go directly to a lawyer who's going to be able to provide very specific advice and tell you. We're an educational based firm. We're not going to tell you what to do. We're just going to show you all the options so that you can choose the best path for you and your family.
Thank you, Mike. That's very helpful. The difference between using an estate planning attorney or sort of an estate document prep company, both are fine. And I like the emphasis on education. That's something that I think I try to focus on in my line of work as well, because I come across it in the financial sector where some people are very disconnected from their investments. They have them and they have a financial advisor. But if you ask them, okay, what do you have? Why is this here? They don't know. They really don't know. They just give their financial advisor, I don't know, $1,000 a month, $3,000 a month, whatever the number is. And they really don't have any idea what the financial advisor is doing. And let me be clear, I'm not necessarily blaming the financial advisor. He may have actually educated the client, but unfortunately, some people just don't want to deal with it. So I appreciate the emphasis on education for sure. So let's start with just the basics. What is estate planning and why should the average person care?
To pair it off of your education, most Americans, regardless of their age or their affluence, they don't want to have anything to do with the estate planning topic. Why is that? Because it revolves around our mortality, our death, and then prior to our death, our possible incapacitation. And while logically we can all understand that death is going to happen, we all know that. We all know that there's a possibility of becoming incapacitated before death. And my opinion is that possibility of becoming incapacitated is ever increasing because of our longevity and our focus on health. Healthier people, when they have a problem, normally don't die the first time they try. They stay alive, but could have some incapacitation issues that have to be dealt with. So first and foremost, with this estate planning topic, a person has to overcome, and this is going to sound a little silly, but it's true. They've got to overcome their gift of optimism that they have time to put these planning documents in place. Now, these estate planning documents, when people hear those words, I'm almost 100% certain that many people say, I'm either not old enough or I don't have enough money to do this estate planning. And
Or I'm not rich enough.
that's what I mean. They just don't have, yeah, they don't have enough to deal with. And that's something that's assumed. That's not a true statement, because the reality is, here's what estate planning documents are. They are succession documents or permission slips. Permission slips for what? To allow financial institutions, medical professionals, and care facilities to receive instructions about your money or your care from somebody else other than you. And most importantly, these permission slips, especially the financial succession documents, they need to be on file with your financial institutions while you're competent. And when I say that, I know some of you listening are going, I have beneficiary designations on my accounts. I have no doubt you do. But beneficiary designations are only addressing one issue of estate planning, and that's avoiding probate. That is just one issue that is addressed as part of a proper estate plan. The first issue that is a blind spot in almost everybody I talk to for the last 3 decades is the need for succession if you become incapacitated. Because I want you to think about something. Most clients' largest assets are their qualified plans like 401k, Roth, and regular IRAs, and their real estate. Qualified plans are not a jointly held asset. They're individually held. And the blind spot I'm referring to is if the owner of that IRA becomes incapacitated, the competent spouse does not have any legal right to access that account either for withdrawals or just money management, unless the incapacitated spouse, when they were competent, put on record a financial power of attorney with the custodian of that money, letting them know who the successor is. With that jointly held real estate, the blind spot there for people I talk to is that the jointly held real estate, that doesn't work like the bank where it's an or, where either tenant or either spouse can get access. Real estate is an and. And when you hold real estate joint with rights of survivorship, if one of the tenants is incapacitated, i.e. a spouse, that real estate can't be sold, or any type of home equity line of credit cannot be obtained without the signature of both tenants. All right? So if incapacitation occurs, families don't have a succession plan in place to allow somebody that they trust to handle the money, the real estate, and the business and medical transactions when they're incapable. And Logan, I want to button that topic up. Beneficiary designations, joint tenants with rights of survivorship or any rights of survivorship planning, or having a last will and testament, none of those addresses the need for succession if you should lose the ability to make decisions for yourself.
Yeah, I think you said it very well when we spoke. I think the first time you said what people don't understand is estate planning is not just about what happens when you die. It's about what happens when you're alive and unable to make decisions for yourself for
And
whatever
if we
reason.
could, sorry, sir, if we could go down that line, once you're 18 years of age, if you lose the ability to make decisions for yourself, nobody's got the legal right to make decisions for you if that 18-year-old didn't have in place a financial and medical power of attorney. So, mom and dad, your adult living at home, who I know you've already had the discussion now that they're 18, your 18-year-old comes at you and says, I'm an adult, I can do anything I want. And the conversation I know all parents have is, you are an adult, but in this house, we're still the rule. And it's because of that thought process, mom and dad think they're in my home, I'm providing for all of their wants and needs, their insurances, their college tuition, etc. How do I not have the legal right to make decisions for them? The answer is right in front of our faces. It's because they're 18 and we're not allowed to make adult decisions anymore unless they've given permission. Logan, sometimes I still have a parent giving me pushback, and this will help that parent really see the light. You can't even take a look at your child's school records at college or university without them giving you permission. So what do you think financial institutions and medical professionals are going to do if presented with a decision that's needed for an adult and there's no liability relieving documents that can be presented to them, relieving them of liability for listening to somebody else about the adult's problem? So Logan, that issue has nothing to do with how much money people have. That issue has to do with being an adult and needing succession documents if you lose the ability to make decisions.
So let's get down to brass tacks a little bit. Let's talk about just quick list of in terms of a basic estate plan, what are the documents they need and why?
Okay. The first estate planning issue that documents are addressing, and the documents I'm referring to would be financial and medical powers of attorney and a revocable living trust. Those documents allow you to appoint successors to make decisions for you if you become incompetent. Okay? If you don't have those documents in place and you become incapacitated, there's a court process. Somebody in your life, whether it's your spouse, adult child, business partner, or a family friend, somebody in your life, in order to make decisions for you, if you didn't put your own permission slips in place, has to take your affairs to a court process called a guardianship and conservatorship proceeding. Okay? The short summary of that court proceeding is that the incompetent person is going to be declared incompetent. They're going to become a ward of the court, which today is called the protected person. And once somebody has been declared as a ward of the court or protected person, hear this. The court-appointed guardian and conservator guard the person, conserve the money. They got to follow court rules on how to use money for that protected person. So what I just said is the husband now needs to follow court rules on how money's being spent on behalf of his incapacitated wife or spouse. Okay? They didn't have to do that before, but now because they haven't put docs in place, Logan, they've got to follow court guidelines on how to make sure the protected person isn't taken advantage of.
The way I like to say it is if you don't do your estate planning, what you're saying is you trust the government to do your estate planning for you.
Yes, and I want to expand on that. It's not a government boogeyman. It's an attorney in a court process. Okay? So to your point, and what I heard you say is everybody already has an estate plan in place. And that estate plan, if you don't do your docs, is somebody's hiring an attorney and taking your affairs through a court process. So excellent point there, Logan. Hear this. The ultimate result of the court process is not only to appoint a decision maker, but that court process gives that court-appointed guardian and conservator paperwork, and that paperwork is given to the incapacitated person's financial institutions, medical professionals, and care facilities that are relieving all of those entities of liability for listening to somebody else about you. So, Logan, what I shared with you is that we can put succession documents in place to avoid the court process, or what do most people do? They do nothing. Therefore, it's that court process that's going to need to be conducted to provide the permission slips for somebody else to make the financial and medical decisions.
Right. So you covered financial power of attorney, medical power of attorney. How does the revocable living trust fit into that? Why is that necessary?
The revocable trust is going to come in for people's non-qualified financial assets, real estate, business entities they own. And what a revocable trust is it's simply a contract of your instructions or a person's instructions on how they want their financial affairs handled while competent, who's going to handle it on their behalf if they become incompetent, and then that same successor after death will be able to step in and follow the creator of the revocable trust's wishes as far as distribution of assets. Okay? Now, the financial power of attorney, let me button this up. The financial power of attorney, when you do a full estate plan, that's going to provide succession for qualified plans because those assets don't go into the trust. And the key, if you do a little research, the key to making the financial POA effective is you got to put it on record with the custodian today. You can't just have it in a binder in your home office and no financial institutions know about it. You want your financial institutions to know about your succession documents right now while you're competent. With a revocable trust, that is actually another way to take title to assets and property. And for those people that establish that contract, they will retitle all of their non-retirement accounts, real estate, businesses, and anything else that has a title, automobiles, boat trailer, golf cart, etc., all into the name of their trust. If that's done and somebody becomes incapacitated because all the assets are in the name of the trust, that new trustee can continue to manage and use assets for the creator of that trust. Why, Logan? This might be a little quick for our audience. Everybody heard me say that you retitle assets into the name of your trust. What that means is if you become incompetent, and we'll talk about death here in a moment, but if you become incompetent, you don't own the asset. You were just controlling the assets in your trust. And you've already provided instructions when you set up your plan that simply said, if I can't make decisions and you're married, I want my spouse to make all the decisions. If we both can't make decisions because we were in the same car accident and now we're both incapacitated, then we have a successor or successors named that can now step into our shoes with the proof we're incapacitated. And remember, all the financial institutions know the names of our successors. And that successor with the legal document, identification they're the trustee, and the proof that you're incompetent, they can now take over and manage your affairs without that court intervention.
Right. So what you've demonstrated there is why a trust is maybe not strictly necessary, but very, very helpful even for an average person. It's not about having a super high net worth. It's about making sure that the succession happens
Miss-
properly and avoids the courts.
That's correct. We're talking about people that have one piece of property, a 401k, a regular or Roth IRA, a bank account, and another investment. Those are people that benefit from the type of planning that I just referred to. You
Okay.
know, if somebody, Logan, if somebody was renting and all they had was a bank account, come on, they don't need a lot of extensive planning. But Logan, they do need that financial and medical power of attorney.
Uh-huh.
Okay. So, excellent point. To benefit from estate planning, the focus for people has to be I'm an adult and I need succession documents in place so that if I become incapacitated, somebody I trust can manage my affairs both financially as well as take care for me medically.
So we handled medical power of attorney, financial power of attorney, revocable living trust. What other documents are part of the estate plan?
Okay. Let's talk about what happens after death. Okay. A last will and testament is a document that lots of folks hear about and are encouraged to put in place. And I don't disagree. The issue with a last will and testament is people are told you need to have a will in place, but nobody's ever educated on how is my estate settled via using a last will and testament. I can tell you how. If your estate is going to be distributed via the instructions that you've put down in a last will and testament, your estate is going to be administered through a court process called probate. Why? Because that's how our country deals with the instructions inside of your last will and testament. Your estate goes through an administration process. And probate administration simply is a supervised time frame where the attorney and your personal representative, that's right, when you're involved in a court process, somebody in your family is going to hire an attorney to take your estate through this administration. The purpose of the probate process is to make sure a deceased person's final bills are paid, final taxes are paid, any contestments are handled. Nationwide, there's somewhere between a 4 and 6 month mandatory time frame that all estates are kept open to make sure creditors of the deceased are notified and paid, taxes are handled, And anybody disagreeing with the distribution of your estate has that time frame to come and contest that they think they ought to get something, or that the distribution language you put in place is 100% incorrect. Okay? Now, most estates aren't contested. And by the way, I think for most people, Logan, it doesn't take 6 months to pay their final bills and taxes. However, if you choose to use a last will and testament as your distribution vehicle, that's the process we have in place, and there's no deviating from it. After that mandatory time frame, the last job of the attorney that is representing the estate is to transfer the assets to the beneficiaries listed in the last will and testament. Now, hear this. Most probates nationwide don't take 6 months. They take closer to a year or longer. And the fees that are paid to the attorney, many people are surprised at the size, because when you add up their hourly charges and you compare their fee, the attorney's fee, to a percentage of the estate, that fee falls many times somewhere between 3 to 7% of everything somebody died with. I know you can do math, but I'll do it out loud. It's not hard to have a $500,000 estate today with a home and other accounts. 3% of a $500,000 is $15,000, and 7% is $35,000. For what? To make sure somebody's bills and taxes are paid, and then the title on the asset is changed from the deceased to the living. That's the for what. Okay? And
So this was a key eye opener for me, that having a last will and testament does not avoid the court
yes,
process.
sir. Check this word out, sir. It's a commencement document for probate. It's not an ending document. It's a beginning document. And if I could add one more item, for those that are listening that own real estate in more than one state, if you choose to use a last will and testament as your distribution document, there'll be probate in every state you own real property in. And more than likely, your family member has to hire more than one law firm, because the law firm that represents your estate in your home state isn't licensed to practice law in the state you have your vacation property in.
I'm dealing with a prospect right now. His mother died intestate, and she has real estate in the state of Texas and in the different country in Spain.
Mm,
He's dealing with probate in 2 different countries, and he said more than once he considered just walking away. Even though there's
100%.
a significant amount of money, just because it's such a
Yeah.
pain, he considered just walking away.
And by the way, dying intestate, ladies and gentlemen, means they didn't put their own will in place. Okay? Not having your own will in place doesn't mean you avoid probate. It just means the state of your domicile is going to direct the distribution of your assets. And that normally is going to go down bloodline, which may or may not be what that person wanted, but it's too late because they failed to put their own instructions in place. Okay?
So whoever the biggest bully is going to be calling the shots.
And check this out, Logan. What the family doesn't know is they could have negotiated the probate fee up front. I'll say that again. What the
Interesting.
family member didn't know is they could have negotiated the fee up front.
Hmm.
Logan, here's the problem. Even for those that listen to this message, if you have legal documents in place, the person that you named as your successor, whether it's in a will or a trust or an attorney in fact in your power of attorney, they have no idea what to do. And sadly, Logan, the person that put the documents in place probably isn't 100% certain how their documents work either. They just feel good that they've got them in place because somebody told them. That doesn't mean everybody understands how they work.
I
Okay?
see this a lot in the financial world, and it goes back to my days as a consultant in the business world too, where there's a lack of follow through and a lack of coordination, which is it's easy to happen. So if you're in a business, it's easy for teams to get siloed over time. And a lot of what I did when I came in and did my process improvement is just be the guy who connects all those dots. And so each team does their thing, but they're not as aware of how it fits into the big picture. And with just a little more follow through, you can get a lot better. I think there's this analogous thing going on in the financial world where most people, they got their investments in their investment guy over here. They got their home and auto insurance over here. Maybe they don't even know the agent. They got their life insurance over here. They got their realtor over here. They got their CPA over here. And there's no coordination
No.
between any of them. And I've had to fight multiple times to get access to these guys to say, hey, if you're making decisions, talk to me. We cannot make these decisions in a vacuum. Your tax guy is looking at taxes in a vacuum. He's saying, how can I reduce your tax burden? But that might not be the right thing to do if you look at it in the context of everything else. I had a client dealing with another financial professional that I trusted, but they were doing in a vacuum and he was looking at debt reduction. And they made a very, in my opinion, a very poor decision that if you look at debt reduction in a vacuum, it made sense. But if you back up a step and look at it big picture, what they did was a bad decision. I think there's a similar thing here. Okay, you've done your estate planning, you put those documents in place, but where's the education and where's the follow through?
I can add on from my 3 decades plus experience. All those professionals that you just named, they don't even have their own estate planning documents done. Just because people are in the financial services world, it don't mean they got it all together and they've thought about succession. If they become incapacitated or die, they've got the same feelings as every other American, which is, I got time. I got time to do that. Okay. Logan, everything you just described there, all of the planning stops, and the ability for all those advisors to communicate with their client upon incapacitation without the proper succession document. Everything stops.
But the other point that I'm making is for people who have done the estate planning, has the successor been educated? Does he know what to do?
No,
Have
sir.
those financial powers of attorney, have they been filed with your financial institution? So you
9 out
put
of
the
10 times, no, sir.
it's you put the gasoline in the car, but then you never started it.
If we could, let's go down that road. There are some people that are listening that have a trust, a revocable trust, and they've not retitled any of their assets into the name of the trust. So they believe that because they have the document, they've heard the education, Logan, this trust will avoid the court nonsense, avoid probate, et cetera, et cetera. But they failed to follow through on the process that actually makes the trust avoid those problems. And that is, you got to retitle the assets into the name of the trust.
Right. And this is where I think the coordination among financial professionals is very important. This is where I think I try to partner with people like Mike. So a lot of estate planning attorneys and estate planning companies out there are usually very good and they do their job very well, but they're not going to hold your hand on the follow through and make sure that you do all these extra steps. I will. That's where I will be with you to make sure we get this done and follow through and follow up to make sure that the estate plan is actually effective. You have a plan in place, but it's not effective until you do the follow through.
And that follow through, Logan, is making sure the assets that should be retitled are. And then you made an excellent point. Your successors ought to be educated, regardless of the planning document that you're choosing to use. There ought to be a meeting with your successors while there's no drama, nobody's ill, nobody's dead, and the successors have a fire drill on what they're supposed to do when the emotional bad times come.
And the good news is this is not complicated. It just requires the discipline and the follow through to get it done. But it's not complicated, right?
No, you just got, sir, you're right. You just got to do it.
Just going to the dentist. You just got to do it.
Or if you want to get in better shape, you got to make some movement. It's not complicated. It's doing it.
Yeah. So it's doing it. But then again, the other point I want to keep re-emphasizing is where I think Mike and I differentiate is with the education and the follow through. Because I've seen it with good estate planning attorneys. We set up this trust. The trustee has no idea.
They have no idea.
The trustee and the beneficiary of that
No
trust
idea.
have no idea.
And I want you to hear this. Many prominent law firms across the country do wonderful documents, and they tell you to put your assets into the trust. And some firms, not all firms, will do the real estate deed, putting your real property into your trust. Logan, if I could mention something, and please, this isn't criticism, this is the way it is. There is a service out there that you can buy, and they give you the opportunity through your subscription to have counsel with an attorney for various legal reasons, speeding tickets, rental issues, etc. But this firm also provides a complimentary last will and testament with the local law firm they're associated with their town. Now, here's my point. They also provide a discounted fee for a full estate plan that includes a revocable trust. I know that the firm out here in the Metro Phoenix area does a quality job with the document. But you know what they don't do, Logan? They don't do any of the real deeds. They don't do the real estate deeds. So people are leaving their firm with a wonderful document. They're feeling fantastic about it. And it isn't going to work the way they want to because they don't put any of their assets in the name of the trust. So
Right.
excellent point that you've brought up there, sir.